This is the third webinar in a series of 4 on estate planning. In this webinar, our presenter, Robert Constantine, will explain the essential planning tools and documents you need as you build your estate plan. Robert is the Senior Philanthropic Advisor at RIT, where he engages with alumni and friends of RIT to assist them with their charitable giving in ways that best fit their personal circumstances and interests. For more than 25 years prior to coming to RIT, Robert was an estate and trust attorney and partner in the Buffalo, New York-based firm Damon and Morey, known now as Barclay Damon. Robert's law practice focused on tax, estate, and charitable gift planning for families, business executives, medical, and other professionals. He was admitted in New York and Florida. From 2003 to 2010, he was Regional Manager of Trust Administration with HSBC Private Bank. Robert is a graduate of the University of Pennsylvania and earned his JD and MBA degrees from SUNY at Buffalo. He is an elected fellow of the American College of Trust and Estate Council as well. Welcome, Robert. Thanks for being here. Take it away.
Okay, thank you, Cindy, and welcome, and thank you, everyone, for showing up. I just want you to know that I'm not a professional PowerPoint person, and as I look at the title's wrong. This is not Essential Planned Giving Tools. This seminar is on Essential Estate Planning Tools. So with that, let's see, page down. Okay. So we're going to actually start right now with a polling question, and just so I get a sense of who's on the line, I just want to know approximately your age. So if you take a minute while I introduce the session here today, fill that in. Just gives me a little bit of a feel for who's on the phone today. So this is the third of 4 presentations. Basically on estate planning, approaching them from slightly different angles in each particular case. We previously did demystifying the estate planning process in the fall. There's a YouTube link. You can go back and look at it. The second one we did in December was life stages estate planning, and once again, there's the YouTube link. And then in June, we'll be doing the 4th of the series, which is really planning for your heirs, dealing with estate plans for with the heirs that you happen to have. So that might mean family, it may mean friends, a partner, a non-married partner. It deals with issues relating to problem beneficiaries, somebody perhaps who does not have financial planning experience or is too young, those kinds of things, and then also planning for your community, and by that I mean, of course, your continuing your charitable giving that you're doing during lifetime and doing it through your estate planning. What I'm going to try to cover today is a lot of stuff, but principally we're going to very quickly review the estate planning process. Now, once again, if you did go to the other webinars, you'll have a pretty good foundation in this, and all of these have a fair amount of overlap. We've got people who've attended one, but not others, and so there is a certain amount of overlap, but the focus today is a little bit different than the others. Hopefully, cumulatively, you'll pick them all up. So we're going to just basically quickly go through what the estate planning process is, which is developing your goals and then developing the plan. Ultimately, that plan will have to be implemented by an attorney who prepares the documents, and then the actual implementation is the funding or transferring of assets into the proper title. This is all stuff we're going to be covering in a few minutes. And then long-term monitoring of the plan to make sure that it is still applicable. Then we're going to look at the common estate planning tools, wills, trusts. There are lots of different kinds of trusts, and I'm probably going to spend more time on that than anything else. Beneficiary designations, and then the perhaps some of the most important documents you can have are powers of attorney and healthcare proxy and a living will. By the way, I want to encourage you, if you have questions, I want to encourage you to ask them. type them in. I may or may not get to them immediately. I'll try to read them as I'm going along, and if it's appropriate, I'll ask it at that time. If it's something I'm going to be covering in a few minutes, I'll probably not answer the question. And then at the end, I will offer an opportunity for you to email me any questions that you have after this, and I'll arrange to speak to you on the telephone or exchange emails with you to make sure that you have all your questions answered. So then finally, I'm going to try to cover how these various estate planning tools fit into your personal estate plan. How do wills, trusts, and all those other documents combine to have a completed estate plan that's appropriate for you? The basic estate planning process is basically to try to accomplish certain things. These are fairly common purposes. You want to provide for yourself for your lifetime. So estate planning isn't just wills and planning for after your death. Estate planning is also making sure that you've got the assets titled in the right way, that you're working with professionals that'll help you. So during your lifetime, if you were to become to the point where you have diminished capacity and perhaps you're at risk of someone taking advantage of you, you have the machinery, you have the mechanism, you have the plan in place that can step in immediately and bring in people of trust to make sure that you are protected. We also usually want to make sure that we support and provide support and security for a spouse if you're married, or that could be adult senior parents. It could be children during your lifetime or after death, and this is all part of the estate planning process for both before and after death. So we want to make sure the children and other heirs are protected and provided for. To the extent that you have a lifetime support of various charities that are important to you, this is the opportunity to include those organizations so that you can continue your giving after death. Ultimately, we want to make sure that whatever is being done here is done in a way that reduces the cost of eventually transferring your assets to the next generations with as little expense and as little transfer taxes as possible. So the steps basically are fairly simple. You have to organize your personal, financial, and family information. We suggest using an estate planning questionnaire. And in the earlier seminars or webinars, I distributed or made available 4 documents, one of which was an estate planning questionnaire. This is just a questionnaire that asks you certain questions about your assets. Who are your relatives? These are people who are traditionally the heirs, but not necessarily will be your heirs, but it's important to know who the relatives are and their ages and where your assets are located, how the title is held, if there are insurance and other types of assets that you have that will pass by a beneficiary designation. Who have you named as the beneficiary of those? This collects all this information in a single spot, and that you will use when you eventually meet with your professional advisors, your attorney, your financial planner. It'll make their job easier. It'll make it less expensive for you to have your estate planning in place. I'll make those same handouts available to you, and we'll give you a link which we will send out to each person who signed up for today's webinar. The process continues as you consult with the professionals that you've identified, and then ultimately your attorney will draft the documents. By the way, one of the planning papers that is part of that 4-paper package is a series of questions that you might want to ask of an attorney, if you're working with a new attorney or seeking to work with a new attorney who's an estate planning attorney, this gives you some questions that you ask yourself and or you ask the attorney that'll help you determine whether or not that particular person is suitable for you and has the experience to handle the estate plan that you need for your personal situation. Ultimately, once all this is done, a plan is only as good as the implementation. So if that requires that assets be retitled, that needs to be done. And then over the course of X number of years, the plan should be continually reviewed, continually monitored, and we'll talk about that when we get to this point later on. Let me talk about title of assets, because this is perhaps one of the most important concepts here in estate planning. How your assets are titled will ultimately determine how they pass on death. And I like to think of this in 3 buckets. In this case, I've used 3 little bubbles. Jointly owned assets, contract assets, assets that are basically governed by contract, like IRAs, life insurance, living trusts, and then everything else. And we're going to talk about each of these bubbles in a minute, but an effective estate plan will coordinate all 3 of these things. So let's take a look at them and see how they work. Let's look at joint assets first. And actually, why we're doing this, while we're doing this, I'm going to throw up one other poll, and that is, I'd like you just to answer yes or no for whether or not you have attended or listened to either of the 2 videos. Once again, if I find that everybody or nobody, if it's 100% one way or the other, I may actually modify my my remarks here. But I probably won't, because we're going to have a mix as we go along. So anyways, joint assets. Probably the most common examples of assets that are titled in joint names are real estate, bank accounts, most commonly done with spouses, and the accounts will usually read Robert and Jane, or the survivor is one possible way it will have. We'll say joint tenants with right of survivorship. There are a number of different kinds of languages that is used to indicate what the title is. If you have a piece of real property between a spouse, it has a legal title, which is that you're held by joint tenants of the entirety, which indicates that the couple is married and the spouse has certain rights that can't be alienated in that particular case, and protections under the law. But anyway, so what happens is when you have a bank account that's in joint name with right of survivorship, this means that either party is entitled to all of the rights and interest in that. So if you have a bank account, either one can withdraw all of the money from it. And on the death of one person, the survivor automatically becomes the owner of that property, of the money in that account, if we're talking about a bank account. Now, in most cases, that's appropriate and anticipated, and that's perhaps why we set it up. This is probably the most common, most widely used technique of estate planning between a husband and a wife, married couple, is having their accounts in joint name with right of survivorship. So, as I said, on death, the other automatically becomes the owner of that account. No probate, nothing else has to really be done. Yes, you might want to go to the bank and provide them with a copy of the death certificate, so they actually change the name on the account. But as far as the rights to that, the survivor owns the asset. This can be a problem. Many older people, especially those who are single or widowed, sometimes will ask a trusted friend or relative, nephew or niece, to help sign and pay bills. And they go to the bank, and the bank, sometimes not following good practice, will add the other person's name to the account so that that person can sign checks. And in some cases, they incorrectly and inappropriately put it in joint name with right of survivorship, where the real purpose is to strictly allow and ask for help, somebody to pay the taxes, or pay the bills. This can be better accomplished by just signing a power of attorney. Usually the bank has its own power of attorney form, which allows that person to access and to write checks, make withdrawals, but on death, the asset then will pass by as just a general asset of that person's estate. So you're not making it a transfer on death when you're just trying to give somebody the ability to write checks for you. So you have to be very careful, and if you're working with a family member or an elderly person especially, make sure that that account is set up correctly. You can also see a situation in a second marriage situation where there are children from the first marriage. So do you put the family residence now into both names with right of survivorship? If the second spouse happens to be the survivor and has children of his own, there's a chance that that house or the value of that house passes outside of the original family unit, and the children of the first marriage end up actually getting disinherited inadvertently. So this is an important area that we need to look at all times to make sure that any joint arrangements, in fact, have been set up appropriately.
Go to chat. Robert, there is a question if you wish to take it now.
Okay. Let's highlight it.
Mm-hmm.
Okay, we have a question as to whether or not this rule varies with other countries. Let me just say that actually this rule varies from state to state. State to state. The rules of inheritance and joint tenancy and things like that are really state issues. So each state may have a slightly different nuance to this, although my sense is that most are generally the same. They may call them the account slightly different. And certainly every country is going to be different. So let's get back to now the second bubble. The second bubble I call contract assets, because I can't think of any other name that seems to work. But if you'll follow my methodology here, I think you'll see what I mean. A life insurance policy, retirement plans, transfer on death bank accounts. These are essentially contractual relationships. For example, if I happen to have a life insurance policy with John Hancock, so long as I continue to pay the premiums, they will pay the death benefits to whomever I designate in my beneficiary designation clause. That's probably one of the most important parts of the insurance policy, because if I haven't designated somebody, the terms of the insurance policy will control where those assets will pass. That may not be what I want. So I designate a a primary beneficiary, and then I'll always designate a contingent beneficiary or series of beneficiaries if the first one is deceased, has predeceased me. Retirement plans are contracts too. I have my account at Fidelity. They are the administrator, the trustee of the plan, and once again, they administer the assets and make distributions to me as required by law or as I direct. And on my death, they will distribute the assets according to the beneficiary designation form that I have completed. A transfer on death is a slightly different nuance. It's fairly similar to this beneficiary designation. But bank accounts used to have what were called cotton trusts, which were bank accounts that basically said, John, in trust for Mary. And during John's lifetime, John had total control over that account. Could make all withdrawals, could close it, could transfer it, do whatever, and draw it right down to zero. But on John's death, Mary became the owner of, or had the right to get the assets out of that bank account. So during lifetime, as long as John's alive, Mary has no rights to make withdrawals, but on John's death, then Mary's interest is accelerated. This can now be done in securities accounts. New York passed a law maybe about 15 years ago that permitted securities accounts to be retitled so that there is a transfer on death designation. The next example of a contract asset is a trust. I'm going to spend quite a bit of time on trusts in a few minutes here, but trusts are basically a contract. They're a contract between the person who sets up the trust and the trustee, the person who is named to administer those assets, and then the trust document says how the assets are to be administered and distributed at various times. During the lifetime of the grantor, perhaps the grantor is the trustee and can control what happens. But the important thing about a trust is the assets have continuity, and in the document you can provide for a successor trustee and provide for beneficiaries. Let me just take one of the questions right now. What happens if your designation on life insurance is 34%, and 33% for your 3 kids, but your living trust reads 40%, 30%, 30%? So that's what this whole webinar, in fact, is about. It's making sure that you have coordinated the designations in your living trust with your beneficiary designation. So the idea of planning is to make sure that your overall goal, and if this particular case is that you want 40%, the 3 children to split 40, 30, 30, then to have the life insurance do something different doesn't really make a lot of sense, does it? So you do one of 2 things. Either change the beneficiary designation and the life insurance so that it's consistent, or maybe even simpler is to designate the trust as the beneficiary of the life insurance if the trust will be continuing for a period of time after the death of the person who sets the trust up. Okay, so those are the 3 methods, or there's the 2 methods. Now the third method is whatever's left. So whatever doesn't pass by joint assets or by some form of contract and beneficiary designation, that'll pass under your will, if you have a will, or by the laws of intestacy. So the laws of intestacy are established in each state, and each state not necessarily 100% consistent with others. For example, Well, let me get back. The one thing about the going through the intestate process, it's the only process that most people find to be more difficult than the probate process. And by the way, because there was no planning involved, it's guaranteed to be the most expensive way to transfer assets, because everything has to be reviewed by the court, proposed by the court, proposed and then reviewed by the court and then ordered. So this is not a desirable thing to have, and it's why I suggest in every case that everybody have a will, even if your primary planning document happens to be a living trust. Yes, a living trust. Now, what is a will? A will is a device that's used to transfer assets, but a will is the entry into what's called the probate process. Most estates are set up in a way where the probate process is avoided, and in many cases this is one of the main goals of a certain number of clients and of attorneys, is to reduce the need for a will by having most of the assets in one of the other two categories, so that there's a immediate transfer of assets on death, and then the will is just kind of a catch-all in case that there are assets that were had not been dealt with, and it's sort of a catch-all. So we'll get into this just in a couple minutes here. Well, here's what New York says about the laws of intestacy where there's no will. If somebody dies and survived by a spouse and children, the spouse will get the first $50,000 plus 1/2 of the balance. The children will split the rest. That may be a surprise to most people who are married with children. They just assumed that the spouse would get everything. You can see here that that's not the case. And then add to that the potential problem where the children are minors. Now you have people who are legally incapable of owning assets, and so you then must petition the court to have a guardian appointed. Wills are usually used not only to transfer assets, but also to designate and to nominate a person or persons to act as guardians of the property of their minor children. If there's no will, you still have to go through the process, but the court has considerably more discretion as to who gets named. Well, if there's a surviving spouse, and if that's and that person qualifies in every way, no child, no criminal or abuse issues or things like that, or abandonment issues, chances are about 99% that that person is going to be appointed. But nevertheless, why leave it to chance? And why spend the additional money to have to present that to the court when it can be done much more simply by just having a will? So what is a will? A will is a document that is effective only after death. So during lifetime, it has no legal consequence during lifetime. It doesn't speak. It isn't valid until the probate court says that it's valid. And that's what probate is. It's the process of proving to the court's satisfaction that the will was properly executed by an adult who was not under any undue influence from anybody and who was competent. And competency is not a very high standard in a will. It's actually the lowest standard in law. You can be pretty much in diminished capacity for any other type of transaction. You could get out of a contract to buy a car because you didn't understand the transaction, and yet that same person that same day could be legally competent in the eyes of law to sign a will. All you have to know is a general understanding of what the extent of your assets are, an understanding of who the natural heirs might be. Whether or not you've named them is irrelevant, but who are the natural heirs? Am I married? Do I have kids? And then third, you have to understand that the document that you're signing will dispose of your assets in a particular way. Beyond that, you don't have to know the exact value of everything and who the president is, all those sorts of things. It's a very low standard. The other thing about the probate process is before the court makes its decision as to whether or not this will be validated, people who would inherit if there had been no will, or whose interest would be greater if there had been no will, are given the opportunity to come into court and to examine witnesses, to slow up the process, and to actually object if there are grounds to object. Now that's the process in New York. Places like Florida and the majority of other states actually permit the contestants to do it after the will is admitted to probate. So you're allowed to do a certain amount of administrative stuff, getting the will admitted to probate initially, but then the potential contestants have an opportunity later on to come in within a relatively short period of time to file objections. What else does the court do? Well, the court appoints an executor. That's somebody who will execute the terms of the will follow the terms of the will, and also the court can appoint guardians of minors, and if there's a trust under the will, this is the time when the court will also appoint trustees. There are court fees, filing fees, and then, of course, there are expenses of an attorney to walk you through this process as well. Who should have a will? I believe everybody should have a will. Certainly anybody who has minor children and wants to have a say in who the guardians will be. You need to cover any contingency that your estate plan, that the other methods have not effectively dealt with every asset, so this is kind of the catch-all. And then don't forget the death may have resulted from negligence is one possibility. So there may actually be a recovery, a lawsuit that may have recovery of assets, and those assets need to be transferred at some point, and so the will is the appropriate document to use in that particular case. Even if as I said earlier, even if your primary document is a living trust, you still should have a will in all events. That's the catch-all. Now let's talk about trusts. Trusts are, I think, one of the most powerful planning tools that we have. They are I would think that for most people with assets that you should consider having a living trust, especially if where there's not a spouse immediately involved. And I would say that even with a spouse, you should consider either a joint trust or two separate living trusts. But let me talk about, first of all, what a trust is. I said before that a trust is just a contractual arrangement between a person who sets up the trust, and sometimes called a grantor, sometimes it's called a settlor. I've even seen the term trustor. New York generally uses, you'll see the term grantor most frequently. That's the person who grants authority to somebody else, and that person is called the trustee. So a trustee agrees, by signing the trust, agrees to manage the assets that have been retitled into the name of the trust. So I'll say the Robert Constantine Living Trust, and I'll have my assets actually transferred out of my personal name into that name of the trust. The trustee does not own the assets. The trust owns the assets. The trustee can control the assets within the trust. Trustee's authority is based on what is referred to as a fiduciary responsibility. So they have to act in a way which takes into account the primary needs of the beneficiaries, both the current beneficiaries, maybe the income beneficiary, and the remainder beneficiaries. So they don't own the assets. They can't, on a whim, make decisions that are inappropriate and that do not put forth the best interests of the beneficiaries. That's what a fiduciary responsibility is. Trust can be set up during lifetime. We refer to that frequently as a living trust. can also use the term inter vivos trust, Latin term that means between living parties during lifetime. Or it can be established under the terms of a will. That's usually referred to as a testamentary trust. Wills are sometimes called last wills and testaments. There's an old historical reason for that, but I won't get into that here. A trust can be revocable, which means they can be changed or amended, or they can be irrevocable. And there are sometimes reasons for doing each. Trust can start out revocable and then become irrevocable. For example, the trust I've established during my lifetime is revocable. On my death, it becomes irrevocable, and that's by design. So even though I may have given my trustee broad discretion to handle assets as he or she deems most appropriate, nevertheless, the terms itself are not going to be changed. I'll just address a question quickly here about, somebody's raised a question. I have a sibling that I would like to not get anything from my estate. I have a will naming my 3 nieces. Does the sibling have any claim on my estate? My sibling is the only living immediate family relative. Well, this is a perfect example of why you would probably want to have your assets in a living trust rather than pass through a will. Because if they pass through a will, and this is a New York probate, I've already explained that the next of kin, in this particular case your living sibling, would have the right to come in and question the validity of the will and perhaps add additional expense and delay just by being obstinate. If there are no assets passing through the will because you've got them titled in the name of a living trust, the trust can continue after death and then pay out to the daughters of your deceased sibling, which is the last sentence here. And the brother has no immediate opportunity to raise any objection. So if the brother wants to cause trouble, he actually has to start a proceeding, which is very expensive. In a probate proceeding, it's not expensive at all because he's invited to the party to come in and to examine the witnesses. In a living trust, on death of the grantor, the trust just continues until the assets have been finally distributed. They may be held for another bunch of years until, in this case, the nieces reach certain ages. But the opportunity there is no immediate opportunity for the brother to object. So that's the strength of a living trust, and that's the strength of having that as the primary document. I would then also obviously have a will in there that just reinforces the terms of the trust, just as a possible backup. But if the assets are in the trust, you should have no problem. And this is the case for any time where sort of the next in kin are not going to be inheriting or are not part of your planning as far as you're concerned. That's why I say in this, going back to the outline, why trusts are most common and the most flexible. So these living trusts, the most common purpose why people set up living trusts is to provide for lifetime asset management for themselves and for a spouse, if there's a spouse. The grantor can be his own trustee, her own trustee, and then you'll designate or name a person as the successor trustee in the event you become incapacitated or die. So during lifetime, the grantor controls all these things, and then on death, the trust can continue. If the grantor becomes incapacitated, the successor trustee can step in. This is a way to protect the grantor from perhaps predators. We've seen stories all the time about abuse of elderly by caretakers and things like that. If the assets are being controlled by a trusted member of the family or friend or a bank, that is much less likely to happen. What else do we use trusts for? Well, to protect our inexperienced or younger or people with diminished capacity, those beneficiaries, protecting them, once again, from themselves and from their predators and creditors. You can provide an incredible amount of flexibility and discretion and give that to the trustee to use the assets as the trustee deems to be most appropriate given the circumstances. So you're basically, the trust is a roadmap, giving directions to the trustee as to how the assets are to be administered, how the assets are to be distributed, and it can be very, very flexible, and it's particularly important. It can also be a learning tool for a beneficiary, especially a younger or inexperienced beneficiary, say inexperienced in managing assets. A good trustee will involve the beneficiary in discussions with the investment manager, so the beneficiary learns the appropriate process of dealing with a professional money manager, can understand how investments work, and the power of solid and conservative investing. So it's a great tool for making sure that assets are not dissipated by somebody who's inexperienced or too young. We talked briefly about a second spouse situation before, and making sure that the inheritance for the children of the first marriage in fact happens. And this is a very common technique where there's been a second marriage to use living trust to keep their assets separate. And it doesn't mean that on the death of the first spouse that the second might not be an income beneficiary of the first spouse's assets, but ultimately the disposition will eventually go down to the children of the first marriage. Trust can be used to avoid federal or state estate taxes. At the moment, estate taxes are not imposed until an individual dies of a little over $5.3 million. And but if somebody has more than that, even though on the first estate, anything passing to a spouse is not going to be taxed. On the second death, presumably there might be tax. So you use trust to split up the assets so they're divided between the spouses, and then estate tax is never imposed on either death. And that's good estate tax planning and requires the expertise of a knowledgeable and experienced estate planning attorney. Another fairly common purpose is a situation where elderly people are anticipating that they will be in need of custodial care in their old age, and they can transfer their assets to what's called a Medicaid qualifying trust. I'm not really going to get into those at this point, but suffice it to say that there are elder law attorneys who hold themselves out to be that, who are experienced in having people's assets go into a Medicaid qualifying trust. They're then entitled to receive only the income from the trust. That income will be used for their care, but the principal assets within the trust will not be considered to be an available resource, and therefore they can qualify for Medicaid coverage, which will pay for the long-term custodial care. Medicaid is really designed for people who are indigents. The idea of these trusts is to make you an indigent. A couple of very, very important planning tools. Let me just take one of these questions here. If you have a living trust upon your death, how fast can assets be distributed to the beneficiaries? And can you just have a living trust instead of both a living trust and a will? I'll answer that second question first. I hope that you've heard me stress that you should not have just a living trust. You always need a will. I can't emphasize that strongly enough. And then how quickly afterwards? Well, don't forget that there are priorities first before the beneficiaries get the assets. For example, aren't these assets going to be used to bury the person who's died? Are there outstanding expenses? Is there an outstanding fuel bill, telephone bill? Who's going to pay the continuing real estate taxes on the house, at least for a period of time? Someone perhaps has to file, unless a person died on January 1, you know, there may be an income tax return that has to be filed for the year, well, there would be, for the year before the person died. Someone's got to pay the accountant to do that. Someone may have to pay the income tax that's owed. So you're not going to distribute everything immediately. This is why you need a trustee who will be careful and make sure that assets don't go out immediately. So if you can answer those questions, how long does it take to be certain that there are adequate assets to cover all the expenses, then I would say that, and to file income tax returns, you could probably make some distributions as long as there are lots of extra dollars. You could probably make some distributions fairly early after death, but the final distributions probably shouldn't be made until 9 months or so after death. If there are estate taxes, if this is a large estate, then it'll be much longer than that because you don't make significant distributions until you know that you've preserved enough assets to pay all the estate taxes. Here's the next question. Can I create my own will, have it signed by a witness, and register with the state court? Well, the way the question is posed is a perfect example as to why you don't want to do your own will. A witness is not going to be valid in any state that I'm aware of. A minimum of 2 witnesses, and some states require 3 witnesses to be present. And wills don't get registered with the state court. You can do it. You can also do your own brain surgery and your own dental surgery. I wouldn't recommend it, but yeah, you can do it. There are LegalZoom and other places out there that give you guidance if you follow them extremely carefully. But even the process of executing a will, the witnesses not only have to attest to say that they saw you sign it, they have to attest that, number one, at least in New York, you appear to be competent. You understood the nature of and extent of your assets. You understood who your beneficiaries are, who the natural objects of your bounty are. In that case that we talked about a few minutes ago, the question asked about where the fellow is avoiding leaving anything to his brother. Well, that's the natural relative. That's the natural heir. That's not the factual heir. This person decided to bypass his brother and pass it to nephews and nieces. The third thing is they have to specifically express that the will is my last will and testament. I'm asking you to sign it. So all of those have to be done formally. A will that is witnessed in the presence of an attorney gets a presumption of validity in New York. I would say a will that's done by yourself, witnessed by non-attorney witnesses without any supervision by legal counsel is subject to scrutiny and is less likely to withstand a strong challenge. So that is a long asset, and that's a long answer to the question. But I feel very strongly that you should, even if you prepare it yourself, run it by an attorney and have the attorney oversee the process of execution. Okay, let me get to these important pieces here, these last documents that are extremely important. A durable power of attorney. Durable power of attorney is a way to designate a person or persons to act as on your behalf on any financial personal matters. They cannot act on your behalf in healthcare decisions, but they can act very broadly on financial and other matters. You can name multiple agents. You can require that they act together, or you can permit them to act separately. Power of attorney is revocable. It becomes effective upon signing unless you designate that it is not effective on signing. I happen to believe that durable powers of attorney are an extremely important document. If somebody becomes disabled or diminished capacity, someone can immediately step in and help take care of financial matters. Now, there's no guidelines as to what should be done, as there would be if the assets were in a living trust. But it's an important document to have if you're traveling and out of the state, out of the country, and something needs to be done. A person back here can handle it for you under the power of attorney. Healthcare proxy and living will are companion documents that allow you to decide for yourself what you want near the end of your life. Unlike the durable power of attorney up above, healthcare proxy only becomes effective if you are unable to make your own decisions or to communicate those decisions to your healthcare provider. It also extends the authority to the agent that you designate, the authority to obtain medical records and discuss the medical conditions with your providers. The living will is actually not a legal document, and it's confused by using the term will. It has nothing to do with transferring assets. The living will is merely an expression of intention. In other words, this is guidance given to the healthcare agent that you've designated. And this is where you say, listen, if I'm giving you this authority, but here's how I want you to exercise it. You know, withhold life-sustaining things or keep me going as long as possibly can be. So it's merely a direction. It's not legally binding, but it is a governing document that can be looked to by the agent. And the agent has to, by the way, has to act consistent with what you would do. So in other words, you name an agent, and if this particular person is absolutely against philosophically against withdrawing and withholding nutrition and hydration, if your condition is immediately terminal, then that's not the appropriate. That person has to follow your directions, not his own philosophical or religious convictions. And if they're unable or unwilling to do that, you need to name somebody else. It's also, you can only name one person at a time. You can have a successor, but only one person can act. A doctor doesn't want to have to sit with two people, one saying yes and the other saying no. So what happens if you become disabled or traveling? A legal matter needs to be dealt with. You want to have a durable power of attorney in place, or you want to have your assets in a living trust with a trustee who can carry on without you being physically present. And the life decisions, as we just talked about, are best accomplished using these two documents. Quickly, when should you be reviewing and revising your estate plan? Certainly anytime there are life events that impact either you or your heirs. If you get married, if your children get married, if there's birth of children. Certainly if you change residence to a new state, if you're moving from New York to Florida or California or Arizona, this is the time that you need to take your documents to an Arizona attorney, a Florida attorney, and make sure that they continue to accomplish your goals. It doesn't necessarily mean you have to change them, but it does mean that you have to have them reviewed. If there's inheritance or you have other significant increase in wealth where you need to do tax planning, that's a good time to do it. Any time that there are changes in laws, certainly anyone who is in a same-sex relationship, either marriage, when there are changes in laws, this is an appropriate time to review and replace your documents with ones that are up to date and appropriate for you in that condition. Review them frequently and revise them appropriately. Are continuing trust appropriate for your heirs at this point, or have they reached certain levels of maturity? Do they continue to need protection, or now do they really need protection? Are there special needs? Has somebody developed a mental condition that maybe requires a special and continuing oversight of their assets? Are the fiduciaries or the trustees, the executors that you designated 20 years ago when you did your first will, are they continue to be appropriate? Are you continuing, are your professional advisors still the right ones for you? Are they still practicing? Have they retired themselves? Is your situation significantly changed that maybe you need somebody with a little more experience? So I've tried to answer questions as we were going along. However, I want to offer you this. My email appears on this particular slide. We will be sending out copies of these slides to everybody who registered, whether or not you're on the phone today. And so if you're listening to this on a webinar, on the YouTube 3 months from today, and you'd like these, but you didn't happen to sign up for it initially, you need to email me. We'll send you a copy of the slides, and I will answer any questions that you have. So if you want to send me an email, give me a phone number and a time to call, I'd be glad to call and answer any questions that you have about this. Stay tuned. Come on back on June 8th and learn about specifically dealing with your troubled heirs, those kids who are even more dysfunctional today than they were when they were growing up. Thank you very much for your attention. Thank you very much for being here today, and look forward to working with you again.
Thank you, Robert. It's 1 o'clock, so that's all the time we have. Join us next time. The next webinar is next week, March 30th. Look for your email. Please remember, you can email your questions to Robert directly or send them to RIT alum at rit.edu. Have a good day. Bye.